Hi, my name's Laura Banks. I'm a partner in the private client team and I work predominantly in the Birmingham office. So something that I'm asked quite a lot by people and wanted to talk today about is when someone might make a gift against when someone might want to make a loan. Loans are usually made in a non-commercial situation when usually it's a parent wanting to give money to their child, but they don't want to give it, but they still want to help them onto the property ladder. For example, giving the money to pay for the deposit. So it is possible for someone, for example, to lend their son £50,000, but it's important that that loan is evidenced, because without evidence of the loan, it can cause complications. The evidence needs to cover the possibilities of both you dying or your child dying. So it's covering when you might want to have that loan repaid. Is it only on your death, for example, or on the death, sadly, of your child? Or is it on the eventual sale of the house in the future? You should have a loan agreement which sets out the terms of the loan, so when it's going to be repaid, as I've already said, but also if there's any interest going to be charged on the loan. The loan should also be secured on the house, so that if your child sells the house in the future, you've got certainty that wherever else the money goes, you're going to get your money back out of the house. So that £50,000 in my example of the deposit for your son's home, does that mean that it's going to drop out of your estate 7 years later? That's the question that we're often asked. And the answer is no, because you're not making a gift, you're making a loan of the money. So the money that you've loaned, the £50,000, that is still your money. So your estate is entitled to have that money back. So it's still a credit in your list of assets, so to speak. So if you died before that loan's repaid, instead obviously of having £50,000 in your bank account, it's an asset of yours and your estate that £50,000 is due back to your estate. So if you had the money, you might have spent it, like on the gas bill, for example. But if you've lent the money, then the money isn't there for you to spend, but it is still an asset of yours. The advantage, though, with lending the money rather than giving the money is that you can have the money back, obviously subject to the terms that you've agreed with your child as to when that loan is repaid. But it is still your asset and you can have the money back. The advantage, as well as you being able to have the money back, is that if your child sadly divorces having married, then when their assets are split, that money isn't part of the assets that are divided up. You are entitled to your loan, so that is an asset which has to come out of the equation before the net assets are then divided up. So it does, to an extent, protect it on the divorce of your child. So you can, alternatively to a loan, make a gift, which obviously is the sort of counterpart to thinking of a loan. So the advantage with making a gift is that after 7 years of you giving that money, it's no longer an asset in your estate. So when you die and all your assets are declared to the revenue, including gifts you've made in the last 7 years, that isn't on the list, because if you've made it more than 7 years ago, then it doesn't have to be added up in the totals. So it is a way of carrying out inheritance tax planning. But of course, the disadvantage with making a gift is that that money isn't yours. You can't have it back. So if you suddenly find yourself in need of that £50,000, unless out of the goodness of their heart your child agrees to give it back, having not spent it or not put it into their house, you can't have it back, so you can't spend it. So it does mean that if your child, for example, dies or divorces or is made bankrupt, the £50,000 that you've given could be lost. So often people want to make gifts to an adult child, but they are slightly hesitant about the in-law. Do they like the daughter-in-law? I'm sure she's lovely now, but will they always be lovely? And it is a worry to parents wanting to make gifts in how they protect that money. One way of protecting it is to make the loan, as I've just talked about, because you're entitled to that money back. But if you want to give the money, so you either want to give it outright to your child, you can suggest most strongly, as part of the negotiation as to the gift, that the child makes a prenuptial agreement if they're not yet married, or a postnuptial agreement if they are married, which will say what happens to that money on any division if there is then a divorce. You could also give the money into a trust rather than outright to the child. So this will mean that if the child dies, divorces, or becomes bankrupt, that money isn't theirs as such to be lost. Although with divorce, a court will look at the resources of the parties and possibly takes that money in the trust into account as a resource to which your child has call on, but that is very specific to the facts, so needs to be looked at on each occasion. But a trust does give some protection, although it has tax implications, so you can't have your cake and eat it. So everyone essentially should take professional advice from someone suitably qualified to analyse what they think about the situation, but also receive advice on the pros and cons of who their family are, what their assets are, what their future needs might be, and whether a gift or a loan is better for them in their situation. If anyone has any further questions, would like to talk to me more about it, I'd be very happy to talk to you, so please do contact me and I'll be delighted to have a conversation. Thank you.